Hi, we have anybody here for landlord tenant? All right, thank you. Bye. Yes, he's not. Okay, I got it.
I'll just go. You want me to sit on your desk? Okay, thank you.
I'm getting pretty good at this, just sitting here doing nothing, but we'll see whether. All right, no one's here for landlord tenant. Could you get me some people? He said no one is here and he won't go get anyone for me.
It's hard to get good help, Judge. It is hard to get good help.
Oh, he's a good guy. He's been assigned back to the courthouse. He was at the jail. Well, let's take a minute and advise the Kilgores of their rights, and we'll see if Ms. Villock comes popping in here. We do have personal service, so she is subject to default. Is she still there in the unit?
Yes, Your Honor, she is.
All right, well, let's take a minute and we'll advise the Kilgores. Here she is now. She's 1 minute late. Ms. Villock, can you hear me? Well, we had a murderous Chucky doll in one screenshot, and now we have a bat in the other one. We don't have Chucky banner anymore, but we got a bat. Good afternoon, Ms. Villock, can you hear me?
Yeah, I can now. I'm sorry. I'm new to this.
All right, we've been waiting for you, but we're here now. Also, Mr. and Mrs. Christopher and Samantha Kilgore are here. You're all defendants in a landlord-tenant proceeding. As a defendant in a landlord-tenant proceeding, including non-payment of rent, which is what the Kilgores are, or termination of tenancy, which is what you are, Ms. Villock, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. And I did send you that information. You have a right to a trial by a jury or by the court. If the action is for non-payment of rent and you are eligible for any assistance, you may not need a judgment to receive that assistance. Summons and complaint from the court case may be sufficient. If the plaintiff is agreeable, the Citizens Mediation Services, Inc. may be available as a possible source of case resolution. If both parties are agreeable to mediation, the court can help set that up. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you waive the rights listed above, but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside the judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment would be set for a landlord-tenant hearing. However, if the judge did not find in your favor, namely me, the original judgment would stand. So let's talk about this. The esteemed Tyrone Fleeman is here on behalf of Erie Street Apartments, known as Medallion Management. And they are asking to terminate your tenancy. I'm not exactly clear, but it looks like you failed to recertify. Mr. Fleeman, what's the status here?
Your Honor, you are reading correctly. This is a termination based on failure to recertify after Medallion sends out the requisite 90, 60, and 30-day notices for an annual certification. Apparently, Ms. Villock did not get that completed, and the management filed a notice to quit, which they're required to do under federal law.
Ms. Villock, what's your position?
I turned in my paperwork. I never got a 30-day notice, but I turned in my paperwork before the first, like it said, And I went into the office and they told me that it didn't matter, pretty much, that it needed to be in 30 days prior to the due date. That was October 1st. I did the paperwork the previous year at the same time. So I'm honestly not sure why this year was any different, but.
Well, they served a notice to quit on you in October 4th. So 90 days before October 4th, you didn't recertify. 60 days before October 4th, you didn't recertify. And 30 days before October 4th, you didn't recertify. So they filed the notice to quit in October. You still didn't recertify. So they filed this action November 14th. And you're saying that sometime before January 1st, you finally filed for recertification?
No, well, yes, but I did it before October 1st when it was due. It
Oh, I
was due by
see.
October 1st.
So you said you did it before October 1st.
Correct.
Well, and I guess I would ask the question when you say did it, and Your Honor, whenever I hear people say they did all their paperwork and they turned in one thing, I automatically know they did not do everything involved in the process, because the process involves an income checklist that they start off with. Then management has to send out verifications. Those verifications have to come back. If management can't get verifications or has questions about things on the income checklist, there needs to be a back and forth. And then eventually a paper gets generated saying what is the amount that's going to be a tenant contribution going forward. I will say also that under rural development guidelines, unlike HUD guidelines, the certification is due 30 days before it lapses. So I think that's probably, and if somebody didn't catch it last time around, Ms. Villock got lucky. It's supposed to be done 30 days prior. That way they can give tenants notice, 30 days worth, of whether the rent's going up or down or whatever's going on. So that's
So the 30-day notice then is nothing. It means nothing then.
Well, I guess we'll find out. Let me ask this. You wish to stay there, is that correct?
Yes, I've contacted legal aid. I'm just waiting to hear back from them again. Because
Okay.
I've sent them over everything. And honestly, I've got a hold of civil rights as well.
Well, the law requires that I adjourn this for at least 7 days. And that takes us to next Friday morning, January 13th.
February.
Are you available at 10 a.m. that morning, Mr. Fleeman?
January 13. What time?
10?
Yep, 10 is good. I've got 9, 10, 9:20, and 9:30 is with you. So I could even do 9:40 if you wanted to.
On the 13th?
On January 13th, Friday, I see a 9 o'clock, a 9:10, a 9:20, and a 9:30.
Oh, okay, I see that. Yeah, so let's set it for 9:35.
There you go.
Ms. Villock, this is a bit complicated. You may have some legitimate defenses that you could use some legal help in exploring. So I'm glad you've contacted legal aid. Are you working somewhere? It looks like you're wearing medical scrubs.
Oh, no, I'm not working at
Okay.
the moment, no.
All right. Who
I'm
else
just-
lives there?
Just me and my 3 kids.
And are you saying you have no income now?
Just child support is the income I have, and that was turned in as well.
Okay. I was just curious because you have to have some income to live in rural development. You have to be low income. You can't be no income.
Well, we'll find out.
For years.
She doesn't want to move or move her kids. And it sounds like, well, I don't know what it sounds like. But we will address this further next Friday morning at 9:35. It's going to crunch us in. I'm leaving for catch an airplane later that day. And now I just found I have another hearing in there, but I'm going to try to do as much as I can during the morning, including all Mr. Thornton's carryover cases.
That's all right, Judge. Your flight's going to get canceled anyways. That's fine.
Yeah, it probably doesn't matter. I was trying to get a flight back from somewhere one time And I had a real short turnaround. I got into Boston and I said, I've got like an hour and 10-minute turnaround. And the lady said, don't worry, this plane's not taking off anyway. So this is it.
Yep. All right, Judge. We'll see you on the
All
13th.
right. That was also known as Erie Street Apartments versus Heather Villock. Mr. Tyrone Fleeman is here on behalf of the defendant. We have the local manager and the regional manager from Erie Street Apartments is here. We had quite a discussion on January the 6th about what the circumstance was, and we're here today. And about 1 minute before showtime, I got notice that Meg Bauer was going to be here, filed an appearance, and here she is. You did indicate that you were in contact with legal aid. Mr. Fleeman had filed with the court a number of exhibits, which probably Meg does not have. I'll start with you, Mr. Fleeman. What's our current status?
Well, Your Honor, our position is basically the same, and that is that she waited until 2 days before the certification was to lapse to even turn in the income checklist. And just for the court and for the record, the process of doing an annual certification is roughly a 3-step process, sometimes more, that involves you start with an income checklist, identifying all of your income sources, and a household composition sheet showing who lives in the apartment. From that, management generates third-party verification forms that need to be sent out to verify the various sources of income reported. When those verifications come back, they then can compile all the information and then have the tenant come in and sign the final certification form and then send it all to rural development. What she turned in 2 days before the lapse, according to her, was the income checklist. So the idea that you could send out verifications and get them back and package it up and send it to rural development by the first, or to have it completed even before you send it to rural development, just getting it completed by the first was virtually impossible. And as such, she didn't comply with the requirement to certify at least annual, and therefore is not eligible to reside in the apartments. And I can cite the statutory authority for that if you would like.
All right, so this is a malum prohibitum rather than malum in se. She didn't dot the i's and cross the t's in a timely manner, so they wish to terminate her tenancy.
And mind you, Judge, this process they start sending notices 90 days prior. They send a 90-day notice, a 60-day notice, a 30-day notice. I think they also sent one additional notice at the 60-day level saying, hey, you're not in compliance with your lease. The lease says tenants will cooperate with management in this process and will have it done at least annually or within the 12 months. Her particular lapse date is October 1st. So they were sending out these notices, and those are some of the exhibits I sent in, trying to get this done. But by the time she turned in her income checklist, it was simply too late to pull it off in the 12-month period.
All right. Ms. Bauer, what's your position?
Thank you, Your Honor, and good morning again, Attorney Fleeman. Our position is that Ms. Villock provided more than just my understanding is that Ms. Villock provided more than just the income checklist. In fact, she provided all of the necessary documentation to prove her sources of income, and that her behavior is characteristic of the duration of her tenancy. She's been at this property for a number of years, and this is pretty consistent timing. In fact, she has turned in the certification subsequent to the annual certification deadline. So there's not just to get back to what you said a minute ago, actually, there's not an intentional desire to not be non-cooperative. In fact, Ms. Villock did participate. Her position is that she participated as she traditionally does participate. Additionally, there's actually a second voucher involved in this. I discovered yesterday. There's no reference to that in the complaint. the statutory reference or the regulation cited on the complaint 7 Title 7, Part 33560 does not appear to point to the right subsidy. I believe this is a Section 515 rehabilitation property, which brings us back into the HUD handbooks, which means that the clients or that the tenant does actually have an increased window to recertify over what Mr. Kleeman has previously presented to the court. I presume not maliciously, of course. So there's a question of fact of what did Miss Vilwalk actually submit? Was it sufficient to satisfy her recertification requirements? And then a question of law, which is what are the were the regulations followed as required for the subsidized property?
And Your Honor, if I may give a brief response, because of the way the programs, be it rural development or HUD, require third-party verification of the income sources, there is almost never a situation where somebody turns in, quote, all the documents necessary. It just simply doesn't work that way. If you have any income source, they have to send out a third-party verification and get it back. I believe in this case, she had 3 of them, 2 bank accounts and 1 friend of the court, I believe. So these were things that had to be sent out to third parties. So it's something of a misnomer for people to say they turned in all of the documents necessary. Like I said, in very few financial situations would that be the case. The programs always require some level of third-party verification. So under any program, 2 days is simply not enough. And even if one program gives the management, not the tenant, but the management additional time to file that paperwork, the tenant still has to have it done within 12 months. And the duration of the time the tenant is there, I think, has a little something to do with this. What we have observed over the years of doing this is that as people live there longer and longer, they do this paperwork later and later and later. Last year, what she signed fairly close to the end of the process was the verifications, those third-party verifications. By stroke of luck, she was able to have sent those out, and they got back within a time frame that they could actually file the certification. Had those third parties not verified last year, we would have been in this position then. But she essentially dodged a bullet. This time around, this was a little further behind the 8 ball, as it were, because this gave them 2 days to generate verifications, have her sign verifications, mail those out, and get those back. It's simply impossible. So it's a little different situation. And it is, I think you're right in terms of the no intent versus malintent, but there is something to be said for reckless disregard. This is a certification. This is the only thing you have to do in subsidized housing. This is once a year. And I believe in this situation, she's saying she doesn't have a job. So it's not like there's no time to do it. And so to wait this long, I think at some point they have an obligation and even a right to say, you can't keep dumping this on management at the last minute. And so that's where they are.
Ms. Vilwalk, I think that's what it comes down to. You have made yourself enough of pain in the neck. They don't want to have you as a tenant anymore, which is important. What's the current rent? What's the rental amount?
In terms of how much is owed or how much per month?
It's changed multiple times. It's hard to say what it is right now, honestly. And
all right, stop with your attitude. This is why they want to kick you out.
Wow, no, it's not.
You haven't complied with the rules, and then you're very disrespectful here. Let's see if we can sort this out. I'm not really in favor of putting you out on the street, but don't make it any harder than it already is. How much is the monthly rent? Can anybody tell me?
Shasta or Amanda, can you tell us that? What is the monthly on this one? I didn't get any ledger because it's termination.
Yep, I'm pulling it up right now. One moment.
Okay, thank you.
Well,
For what it's worth. Oh, my apologies.
currently, Amanda, it's full market, right?
Well, right.
Okay, so that
Correct.
would be the
It's-
789,
The note rate, correct.
789.
Oh, all right, so before that, if she had, what was it during the certification period?
580.
I think
Your Honor, that doesn't
So-
match the documentation that I've seen. And as
Well,
I
I'm
mentioned, there's
we're not doing this as a non-payment of rent. I'm just trying to get a ballpark figure of what her rent is.
I understand.
And so they're alleging that she was blasé about turning the stuff in. They don't allege that she's otherwise a bad tenant, but they're tired of dealing with this. So they want to terminate her tenancy, which means she and her children are going to be out on the street with an eviction on their record, when if they wish to, they could accommodate her and go through the process now, but they don't wish to.
Actually, Your Honor, if I may interject, with rural development, it's not a question of whether they wish to. If they don't get that turned in by the 10th day of the 13th month, that subsidy simply stops. And so at this point, rural development has canceled that agreement. So the only way to rectify the situation would be to start her back up on a subsidy as if she were a brand new tenant, as far as rural development paperwork goes. Amanda, tell me if I'm wrong on that. I think that's correct.
Correct. Yeah, we would have to start the process all over.
I'm sorry, I don't mean to interrupt, but what was the first part of that he said? He said something about the 10 days of something. I'm sorry, I didn't understand that. What does he mean? Or what does that mean?
Management has to turn that paperwork into rural development completed with the third-party verifications and your signature on the final 50059 form it's called. And all that has to be sent to rural development by the 10th day of the 13th month. So that's the 10 days they have to actually package it. The tenant is supposed to have all the rest of it completed before the lapse date. Technically, they want you to have it done 30 days in advance so that if there's a rent increase, they can give you 30 days notice of that rent increase. That's why they start this so far in advance at 90 days and set up an appointment. They're even saying in their first notice that they need to get with you by July 10th. They started this back in July 1st saying, hey, get with us by July 10th so we can get this ball rolling, get this process going. So between July 10th and September 29th, that's a lot of time that rolled off the clock.
The exhibits, they're not yet admitted, but exhibit 2 shows a 90-day notice on July 1st. Exhibit 3 shows a 60-day notice on August 1st, listing rent of $719. Exhibit 4 is a 30-day notice. It says July 1, that's October 1 is the date of that. So multiple notices went out and they were listing rent at $719 per month. Then whatever got turned in on the 29th, apparently, of October.
Of September.
I'm sorry.
They said.
Oh, September, that's right, you're right, I'm sorry.
All right. So they allege that those are sufficient grounds to terminate the tenancy, which they probably are. Ms. Bauer, how do you respond to that?
I have two responses to that, Your Honor. First, by what Mr. Fleeman just said, there was in fact still time for the plaintiff didn't allow the process to proceed before deciding it wasn't going to work with her because there were yet further days. My understanding is that management told Ms. Vilwalk, you missed the deadline. The first is come and gone. It's too late, period, full stop. But it sounds like that was not accurate. And so therefore they should have proceeded with trying to process that paperwork. But more importantly, I think, is the balancing factors of the harm to the plaintiff versus the harm to the defendant, and the risk in not just pumping the brakes to make sure that the regulations were followed. We haven't heard any any position that the plaintiff is going to suffer irreparable harm by getting to the bottom of this. And yet, obviously, we know the harm to the tenant is pretty drastic. If she really is within the scope of what she is allowed to do under the federal regulations, which I believe she is, then it doesn't make sense to unwind this after the fact and have to come back here and revisit this when we can get the right answer. I can see the plaintiffs, and this is not an intentional, I hate actually the idea that legal aid pulls a delay tactic. It's just a simple matter that Ms. Vilwalk's case didn't get through our case review system or process until yesterday. So that's the reason that I would ask the court to give me a chance to actually make a legal argument about the proper regulations that should be followed when it appears to me and my colleagues that they weren't.
Well, if the standard were harm to the tenant as opposed to harm to the landlord, nobody'd ever get evicted. There is certainly a balance. This is much more profound an effect on Ms. Vilwalk than it is on the landlord for not having the paperwork turned in a timely manner. There's no other allegation that there were other violations of the lease, but she wasn't taking matters as seriously as she should have. So I have two options. One is to just grant the motion to terminate the tenancy and make you ask for a stay or to appeal it. And the other is to grant a continuance give you an opportunity to file a proper answer. You indicated in your argument that there may be another funding source under the federal rules, Section 5 rather than Section 8, that may give her more time, but she wasn't past the deadline. She needed to do it by October 1st. She did it by September 29th, which certainly wasn't prudent, but I'm not sure that constitutes the violation. Also, Mr. Fleeman's allegation is that somehow their hands are tied and they have to do this because she didn't comply with the terms. There must be some other solution, and there's more to this. They don't want her as a tenant, and they're willing to go to the mat on it. Probably the prudent thing to do is to grant a continuance at defendant's request to file an answer. Excuse me, I'm gonna be gone for a while before getting backed up here. This makes me want to be gone even longer. Yeah, I'll come back in May.
Maybe it'll be warmer at that point.
Possibly. Let's see here. Of course, I never have any place to put this stuff. I already have a complicated motion. They put it in there and they don't tell me what it is, which is a source of irritation. V27. I have a 1 hour hearing on the afternoon of January 27th. Mr. Fleeman, are you available at 2 o'clock on January 27th?
I am available at that time.
To 2 p.m. January 27th, 2023. Ms. Bauer, you have until today's the 13th. I'm going to give you 10 days to file an answer so Mr. Freeman can see it before the hearing. And
Thank you, Your
as a
Honor.
practical matter, you haven't had a chance to see his exhibits either. So, Ms. Villock, don't spend your money. Set each month's rent aside. If it comes to an issue where the thing is going to be continued, that may be important.
Well,
Stay in contact with your counsel at legal aid, but they are asking to terminate your tenancy. If they prevail, you'll be compelled to move. If your attorney prevails, you may be able to stay, but you're going to owe a substantial amount of rent. So just as a cautionary tale, hold on to your money. There are legal issues, equitable issues, and factual issues here that we're going to address further. I'm going to block 1 hour. All right, I will see everybody on January 27th at 2 p.m. Ms. Villock, do you have any questions?
No, sir.
Ms. Bauer, do you need to talk to her in a breakout or anything?
No, thank you, Your Honor. I can call her.
All right. She got two things going here. Good afternoon, Ms. Villock. Can you hear me?
Yes.
Okay, you had some trouble getting connected, but we seem good now. Meg Bauer sent me an email. Oh boy, 1 second before trial, she sends me a bunch of stuff.
And Your Honor, I think I just got that email as well.
Or could I have a yellow pad? These are all filled up.
Oh, no.
And Amanda and Tony, I just forwarded you that email.
Don't throw those, just leave them
Oh, just
here.
leave
but I
them,
need
sorry.
them. You did, I guess I've used them. All right, good afternoon, everyone. It appears everybody is here. Let me turn the record on. This is file number 221630LT. It's titled Three Rivers Limited Partnership Medallion Management, also known as Erie Street Apartments versus Heather Villock. Ms. Villock is present here by Zoom, as is everyone. She is represented by attorney Meg Bauer from Legal Aid of Western Michigan. Mr. Tyrone Fleeman represents the plaintiff. He is present. Their site manager, Shasta Sluice of UIS, is present. We have two people from the corporate office, Amanda Palmerton and Tony Ogden. I got some earlier things, and exactly 1 second ago, I got some stuff from the defendant. I'll set that here. Wait for that dumb door to stop beeping. This is a termination of tenancy matter. The plaintiff has been attempting for some time to terminate the defendant's tenancy under the obligation that she failed to recertify in a timely manner as required by the federal regulations for this type of housing. We've had several previous hearings, January 6th, January 13th, And on January 13th, we continued the matter for this afternoon for a contested hearing. So I'll start with you, Mr. Fleeman. What's our current posture here?
Well, Your Honor, it's still our plaintiff's argument that the defendant failed to cooperate with the recertification process by turning in her initial paperwork, or they call it an income checklist. And I'm sorry, my printer is printing, so I'm printing off the stuff from Agatha. I don't know if that's bleeding through, but our position is that she turned in her very first paperwork, the income checklist, 2 days prior to the certification lapsing. Within those 2 days, it's virtually impossible that management could have gone through the paperwork, generated the specific third-party verifications, got the tenant to sign them, mailed them out to the third parties, and received them back in time to complete the certification by the date that it was supposed to lapse. So, Your Honor, I did receive the answer from the last hearing, and one of the articles was relative to the fact that we had not attached the entire lease package to the pleadings, and we have typically done that because, as you can now see, I've submitted an amended Exhibit 1, which is the full 33-page version of the lease that was executed back in 2018 when the defendant first moved in. I've also submitted an Exhibit 1A, which is the latest lease renewal version that we have prior to the 2022 recertification. I would move to amend my pleadings to insert the plaintiff's amended exhibit number 1 into the pleadings as part of the original filing. Basically, as a matter of environmental consciousness, we tend not to waste this many pages of paper for cases that don't really require it. Here, there was some questions, so for sure we supplied the whole thing. Essentially, the argument that the defendant is...
Let me stop you for a minute. Do you have any objection to that, Ms. Bauer, to including those, the full lease and the amended lease into the record? I think she's frozen.
I think she's froze.
It's really cold out. This is going to be problematic. Looks like she may be.
And she just emailed, where to go? I can currently hear the proceedings, but my Zoom application has frozen. I do not object to the inclusion of the full lease.
I'm going to remove you, Meg, and have you log in again.
I like Meg this way.
Where she can't speak.
I hope she heard that. I hope she heard that before she went away. But
accepts the amendment, so it is added.
And I'm sure she would have said the same of me. I'm sure of that.
I can always mute you. I can mute from this end, but I can no longer unmute. So once I mute somebody, people struggle then getting unmuted.
Well, and Judge, I was just in Allegan's Zoom, and when somebody's got noise going on in the background, it keeps bleeding over, and I keep wondering, why won't the court just mute them? You know, just because it blends into everything and it really makes it hard to hear. But what you're saying makes sense. If they mute that participant, they won't be able to unmute them and get them back.
We had that feature. They were gonna add some other features. The one we also have, we can't change anybody's name until we bring them in. So if they're logged in under some inappropriate name, we can't do anything with it until we bring them in. And but everybody here is an appropriate name.
And likewise, I had another court over in the phone where I was in the waiting room and they sent me a chat asking which particular cases I was on because they had something else going on. And I found out then and only then that you can't chat when you're in the waiting room. Until they actually bring me in, then I could actually respond to their chat. But while I was in the waiting room, I could not. So yeah, there's definitely bugs to be worked out in the system, but it works pretty well for what it is.
All right, well, she's moving. That's good. Ms. Bauer, can you hear us?
I can,
All right.
and you can hear me. That's great.
Yes. All right. You heard what Mr. Fleeman said. We didn't realize you were frozen until we requested a response. So he has several witnesses here prepared to testify regarding this. is there anything that can be agreed upon as a factual basis? And we're just arguing legal matters? Or we're gonna have to dot each I and cross each T?
Well, Your Honor, the only factual matters that I have, I don't think are in dispute, and that would be the notices that were sent. That would be my exhibits 2 through 5, 2, 3, 4, and 7. I got out of order with my numbers there. Number 7 was actually sent in August, but those are the notices that were sent to Ms. Vilwak as part of the certification. I've not spoken with Ms. Bauer to know if they stipulate to those. Ms. Vilwak indicated she turned in her income checklist 2 days before the certification lapsed. I think we're all in agreement on that. It's subsidized by rural development. We're in agreement on that. I did submit a couple of other exhibits, a number 5 and a number 6, and those are from previous years' certifications where they had to give incident reports on those. But likewise, I've not spoken to Ms. Bauer about those exhibits. But factually, no, Your Honor, I think we're on the same page.
All right, well, let's confirm that. Ms. Bauer, I'm having trouble reading Exhibit 2, tenant certification. I'm not sure what date that is. 4/1/18.
Are you referring to my exhibit B or plaintiff's?
Plaintiffs, these are plaintiffs' exhibits.
Okay, I had to close everything. So I'm still re-pulling up the plaintiff's exhibits at this immediate moment. I believe Mr. Fleeman's outline of the facts, though, is fairly consistent. I would refer to my client's testimony on the exact date that she delivered the documents to the plaintiff, and I have some rebuttal exhibits showing when she signed her certifications on the 23rd of September. But I guess I can't answer to the plaintiff's second exhibit till I can look at it here.
And Judge, you said it's my exhibit number 2 that you can't read?
Well, I might have to go online and look at these. I've got dozens of pages, but there's amended plaintiff's exhibit number 1.
Yep.
Which says it's 33 pages long.
Yes, sir. And the first 2 pages of that are the certification summary.
Yes.
3 pages, sorry, there's 3 pages there. And then the lease actually picks up on page 4, the typical lease.
And then there's 1A. I'm looking for 2, 3, and 4, and 7. They may still be electronic. Here we go. Exhibit 2 is the 90-day notice dated 7/1/22. Exhibit 3 is the 60-day notice dated August 1/22. The exhibit 4 is the 30-day notice dated 9/1/22. Exhibit 5 and 6 are incident reports about not yet certifying.
And Your Honor, I'll point out those are from August of 19 and September of 21. That was for purposes of showing the prior issues they've had with this.
All right. I didn't understand that. So previously they had difficulty.
But number
And
7 is
seven
current.
Is the incident report from August 1st of 2022. May we stipulate to the admission of exhibits 1 through 5? Or 2 through 5?
Can I get clarification on Exhibit 5? I have gotten lost in all of the plaintiff's documents here.
Number 5 is the August 30, 2019 incident report regarding coming in to do the certification process.
It's you may argue it's not relevant, but it's a previous problem. And then September 1 of 21 is the previous problem. Then exhibit 7 is back to the current year, 2022. So exhibits 2 through 7, 1 and 1A are admitted.
I have no objection to exhibits 2 through 4. And I guess who is the resident manager that signed exhibit 5?
Amanda, do you know who signed number 5 back in 2019?
Yes, that was a previous resident manager, Mandy Christoffel, I believe was her last name.
Okay. And then in the exhibit 6, that was signed by Marcia Petrowski, I believe.
Correct. She was a previous resident manager as well.
Okay. And it looks like Marcia signed number 7 also, right?
Correct.
All right, well, 2 through 4 are admitted by agreement. 5 and 6, the plaintiff presents, the defendant objects, lack of relevance. Court finds they may be admitted as a business record. And they are relevant to previous problems in previous years. So 5 and 6 are admitted over objection. And 7 is the current year. Do you have any objection to that, Ms. Bauer?
No, Your Honor.
7 is admitted. All right, now I'm going to ask everyone, Ms. Vilwalk, Mr. Ogden, if you would unmute your microphone and turn your screen on. Ms. Sluice. And Amanda Oil, please raise your right hand. You all swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
I do.
Correct.
All right. Ms. Palmerton, we admitted exhibits 5 and 6 over defendant's objection. Are those documents, records kept in the regular course of business of Medallion Management for
Yes.
the Erie Street Apartments complex?
Yes.
And as part of your management responsibilities, are you responsible for assisting to keep the records of the company?
Yes,
And do you believe those are accurate records of your company?
I do.
All right, they're admitted. All right, so we've got most of our operating facts in order. The defendants can clear up the date that she filed. All right, Mr. Fleeman filed earlier today what he calls Plaintiff Exhibit 8, which is the Code of Federal Regulations. It's very helpful because those are very hard to research and hard to find. This is a state court and we deal with state law, but when we deal with federally subsidized housing, these federal rules apply. So this is simply a copy of the Code of Federal Regulations 3560.152 tenant eligibility. Mr. Fleeman is going to argue certain clauses of this. It isn't a testimonial, it's just a copy of the statute, then I will allow it. So Exhibit 8 is also admitted.
Your Honor, I have to say I've never been sure if I should actually call that an exhibit or simply a bench filing, because you're right. It's,
Well, exhibit is fine. At least we'll be able to find it if we have to look for it.
okay.
All right. So you've got, is that essentially the plaintiff's operative facts?
It is. It is.
Do you wish to elicit any testimony from any of your witnesses?
Well, Your Honor, I do, but I think I need to make an opening first for the testimony to make any sense.
All right, that's probably appropriate. Now, Ms. Bauer, do you wish to sequester any of the witnesses?
Yes, Your Honor. You took the words out of my mouth.
All right, now I'm going to put you in the waiting room. You are not to look at or listen to any YouTube broadcast of this presentation. You're sequestered. You're not to hear anybody else's testimony. So I don't think anybody has YouTube up, but you'll be in contempt of court if you are listening to or watching the YouTube view of this. You all understand?
And Your Honor, because Amanda will be my first witness, is she? Okay.
All right, I'll put Tony in the waiting room. Don't go away. The things are skipping around. Ms. Vilwalk, you're entitled to be here through all proceedings. All right, Mr. Fleeman, your opening.
All right, Your Honor, just some subsidy 101 for the record and maybe for the court. I know you and I have spoken about subsidies a number of times, but from the 40,000 foot view of subsidy in housing, there are two basic types. One is project-based, and that would be your standard HUD or rural development or now low-income housing tax credit, where they have subsidized or given a mortgage for the construction of the property or a complete rehabilitation of the property. That's what we call project-based. And that's what things like 7 CFR 3560.152, or you'll see it on our pleadings often, 0.159 is the part of rural development that speaks about terminating tenancies. There's also in our country, world, state, tenant-based subsidies. Those are referred to as vouchers. There are a couple of different types of vouchers, but for purposes of today's case, we'll just be speaking about Section 8 housing choice vouchers that are tenant-based. So a tenant-based voucher goes with the tenant. If they want to leave Erie Street and go to apartment down the road, that voucher can go with them. Project-based stays with the project. So that what we have here, as if you probably have figured out, is the project itself is rural development, subsidized. Ms. Vilwalk at the same time has a MISTA voucher. Now, something else that we need to cover is that MISTA vouchers, the certification for those and the financial implications and how much the tenant pays versus how much HUD pays, that's all dictated by a certification process that the tenant goes through with a third-party organization. There's a couple of them around the state. This one, I believe, is Housing Choices, LLC. They are the people with whom Ms. Vilwalk does her certification to satisfy MISTA. Excuse me. Also important to note, MISTA is a branch of HUD. So that's very important. MISTA is the Michigan arm of HUD. And why that's important is that basically, not to put words in the defendant's mouth or her attorney, the argument here is that because Ms. Vilwak completed her certification relative to her MISTA voucher, the certification process for the property is not necessary, that she does not need to do the certification for the project-based subsidy. And I think in this case, defendant is confusing the HUD regulations with the rural development regulations. Under the HUD regulations, and this is found in the HUD handbook and statute, there is actual language that basically says that if a tenant lives in a HUD property and also has a MISTA voucher, the HUD property does not need to do the certification. I think the word Ms. Bauer used is duplicitous, and this is a good example of that, where because HUD and MISTA are two pieces of the same HUD pie, it doesn't make sense to have two different certifications going on, or at least that's my supposition. But that is language in the HUD regulations. That language does not exist in rural development regulations. And anybody that's ever dealt with rural development and HUD will tell you, and Ms. Palmerton will testify to the fact that they do not share information. Not only do they not share certification information, I've done fair housing violation cases where rural development will do an investigation, HUD will turn around and do another investigation, and they do not share information. I don't know why, but it's always been that way. And the same is true with these certifications. Again, Ms. Palmerton will testify to that. The rural development regulations, specifically 7 CFR 3560.152, do spell out the eligibility requirements, and I think defendant cited Section A, general requirements that say that a tenant to qualify for agency financed housing, which is the way they refer to rural development project-based subsidy, they must qualify as very low, or moderate income, or be eligible under requirements established to qualify for housing benefits provided by sources other than the agency. And when they say the agency, they're referring to rural development, such as U.S. Department of Housing and Urban Development. That would be a HUD, Section 8 assistance, or low-income housing tax credit when a tenant receives such a housing benefit. So the argument set forth in the answer is that that language stands for the proposition that if if a tenant like Ms. Vilwak does the certification necessary for the MISTA Section 8 voucher, they don't need to do, they are, quote, qualified for housing there. But the reason I submitted 3560.152 is that if you jump down to Section E, which is on the second page, where it speaks of tenant certification and verification, it says tenants and borrowers must execute an agency-approved tenant certification form establishing the tenant's eligibility prior to occupancy. In addition, so this is another clause. The first one was satisfied by Section A. In addition, tenant households must, again that word must, be recertified and must execute a tenant certification form at least annually, or whenever a change in household income of $100 or more per month. Then it goes on from there. But they make it very clear that it has to. When you jump down to E14 IV, it says tenants who fail to comply with tenant certification and recertification requirements will be considered ineligible for occupancy and will be subject to unauthorized assistance claims if applicable as specified in some part O. The key part there is that sentence is an if-then sentence. Somebody could move in and be qualified under the general requirements. This sentence says, if you don't do this secondary requirement of annual certification, then you no longer qualify to live here, and they can proceed with eviction. While we're on that statute, I'll also direct the court's attention to Section E2.4, and this starts at the bottom of the second page. And it says, since tenant certifications are used to document interest credit and rental assistance eligibility and are a basic responsibility of the borrower under the loan documents, borrowers who fail to submit annual or updated tenant certification forms within the time period specified in E2.3 above of this section will be charged overage and lost rental assistance. So there are actual penalties that ascribe to rural development landlords who do not get tenant certifications completed within the 12 months or who don't take steps to terminate the tenancy, which is what they've opted to do in this situation. So that is where they start. Then you go into the lease, and the lease has several paragraphs that are relevant to this issue, where they say that this process must be completed. And would you like me to go through that part too, or?
No, just a minute.
Okay. I know I'm covering a lot of ground here.
When that statute refers to borrower, they're talking about the complex, the people that borrow the money to build the complex. So that borrower means Erie Street Apartments, Medallion Management.
Yes, sir.
And they're subject to sanction. All right, so this is all well and good, and it was very helpful to have this statute in front of me. Ms. Villawak was asleep at the switch for 90, 60, and then 28 days. And on the second to the last day, she did a portion of it, which has caused all of us and thousands of dollars to try to rectify this. Person hours, legal fees, court time, court staff, legal aid. We're all here because of this. However, there's a serious consequence to the defendant. She's evicted. She is forced to be removed from her house, and I think rent was either low or none. When it went back up to market rate, it was $750 or something. And she's going to be exempt from further placement in subsidized housing, and she'll lose her Section 8 voucher. So is there any middle ground, or we're simply going to go to the mat on this regarding the defendant's lack of diligence?
Well, Your Honor, I believe there is middle ground in the form of, I'm sure my client would be willing to do a conditional dismissal if Ms. Villawak were willing to voluntarily vacate. I don't know that that's really much of an option, but the conditional dismissal would at least prevent the second harm you speak of, which is the ongoing inability to get subsidy going forward. So I'm sure they would be willing to do that, but in all candor there to the court, and I've already explained this to Ms. Bauer, there are a number of other lease violations that by all rights should have been included in this notice to quit. Through clerical error, were not included in this notice to quit. So we are only here on the basis of the failure to recertify, and under HUD regulations, you are bound by what you have in your notice to quit when you go forward. So we can't very well add those other items now.
Bottom line is that they want Ms. Villawak to vacate.
That is correct, but are willing to do so in the form of a conditional dismissal.
Ms. Bauer, have you discussed that with her at all?
Only briefly, and not, Mr. Fleeman and I have not had much conversation on this case.
Judge, we've both been scrambling. We've both been busy upon busy. These multiple court hearings are killing all of us. So no, normally Ms. Bauer and I would have spoken.
I can certainly identify, and you're both here servicing my court, and I appreciate it, but I know I'm only one of many courts that you appear in. Ms. Villawak, I've known you since you were running cross country in the 9th grade. If they get what they ask for, you're gonna have to move out of this apartment in 10 days. And the sheriff will come put your stuff out in the street. And you won't be eligible for any other subsidized housing. The apartment complex has drawn a line in the sand. They've cited the statutory authority under federal law. I haven't heard your attorney's side of the argument yet. But if they win, you get 10 days to move and you won't be able to get in anywhere else. The conditional dismissal that he spoke of is an opportunity to give you some additional time to vacate. And if you vacate voluntarily, it would be dismissed and it wouldn't reflect on your ability to get into other housing or keep your Section 8 voucher, which is important, I know. So I don't know that anyone's had a chance to discuss that. I'm not trying to force you into settling. I've got all afternoon here, but there's a serious consequence to you if they win. And it looks to me like they've got 5 bullets in a 6-gun cylinder.
Judge, would you, I'm sorry. I was going to say, if you would like to put us in, if you'd like to put Meg and Ms. Vilwak and Amanda and I into a breakout room, we certainly can have conversation that, again, in all candor, Ms. Bauer and I just simply haven't had where we, in years prior, would have had.
Meg, is that agreeable with you?
I'm certainly agreeable to a conversation. I would perhaps ask, I submitted a statutory excerpt in response. It was labeled as
You did.
defendant.
You submitted it 1 second before the hearing started. I haven't had a chance to look at it yet. So I'll look at it while you guys are in the breakout room.
That's exactly what I was asking. And I am noticing that I did not include an excerpt from the first chapter. I dropped it on the printer, I guess, which I didn't see Mr. Fleeman's filing until about half an hour before we started. So I tried to scramble something in response, but the very first page of that excerpt, which I was prepared to share my screen with at least, shows the applicability of the handbook, that it's a rural development handbook that I cited. But yes, I'm happy to engage in conversation. Of course, I believe we should always be trying to have amicable resolution. So.
All right, I'm gonna assign you all to the breakout room. Amanda, Heather, Meg, Tyrone Fleeman. All right, everybody click join.
Judge, I think you beat us to it by about 60 seconds. We were just on our way back in.
Okay, very good. All right, we're returning to the record in the matter of Three Rivers Medallion Management Limited Partnership versus Heather Vilwak, 221630 LT. All the parties are back, including the sequestered parties. They've been waiting patiently. Parties have been discussing this matter for some time in the breakout room. Ms. Vilwak, can you hear me?
Yes, I can hear you.
All right. I'll defer to you, Mr. Fleeman. What's the status?
Your Honor, we had some discussions, but we're not able to reach a resolution and therefore need to proceed with the trial.
Very good. All right. That means I need to sequester the 2 witnesses.
Yes.
I have a criminal matter that I'm going to have to attend to at some point, so I'm going to have to interrupt this. But Mr. Fleeman, you've made your opening statement. Ms. Bauer, do you wish to make an opening statement now or reserve?
And Your Honor, I actually have more to do from an opening type of perspective. I can have the witness go through the provisions of the lease, or I can go through and read them in the record. Probably faster if I do it.
All right. Go ahead.
Your Honor, I'm looking at the Exhibit 1A, the amended not 1A, sorry, amended Exhibit number 1, which is the original lease and is the full lease. And I'm going to direct the court's attention to page number 6, and these are the hand-numbered. I had to hand-number this because these documents don't have page numbers on them, but for reference sake, I wrote hand numbers on them. So going to page 6 of that, you'll get to paragraph 8 of the lease, which is eligibility requirements. Looking down to the second to last, or third to last sentence, I think it is, the tenant agrees to cooperate with this process. And I would key in on the fact that it says process, not just turn in your income checklist, but process. By providing all required income and household member information, tenant will receive an annual recertification notice during the period of 90 to 75 days prior to the end of the lease term. Tenant will receive another written notice 30 days prior to the end of the lease term. Now, here I would make the argument that this client actually sends out a 90, a 60, and a 30, as well as an incident report at the 60-day mark. So they actually send out 4 notices when 2 are required. Last sentence is the most important. Failure to respond to recertification notices and provide necessary certification information is material noncompliance with the lease, will result in tenant being charged market rent and termination of tenancy. Moving forward to paragraph number, it's on page 8, but it's actually number 9. J speaks of income certification. I understand that income certification is a requirement of occupancy, and I agree to promptly provide any certification and income verifications required by management/owner to permit determination of eligibility and, when applicable, the monthly tenant contribution to be changed. And it keys on requirement of occupancy. This is not eligibility. Eligibility is set forth in section 152 when they first move in. This is a requirement of continued occupancy. Next, I would direct the court to page number 10 of the lease. This is paragraph 10C, C, and it speaks of notice of rent increase obligation to cooperate with recertification. Second sentence says, in the same manner, at annual recertification, a 30-day notice shall be given of rent change. This 30-day notice will not occur if tenant has withheld income change information from agent or is delinquent in providing income necessary for the annual recertification. Should tenant not cooperate with the recertification procedure, upon expiration of the current certification, tenant will be charged note rate and eviction proceedings will be instituted. A couple things to pull from that paragraph. One is that it speaks of cooperating with the recertification procedure. It's not a one and done. You don't just turn in paperwork and you're done with it. You got to cooperate with the procedure. My argument, of course, is waiting until 2 days prior to the expiration is not cooperating with the procedure. The other thing I wanted to point out in this paragraph is that the concept in all subsidy, and I think Ms. Bauer will support me on this, is that they want to have these certifications done 30 days in advance of the lapse. That way you can give tenant notice that, hey, the rent is going to increase for 30 days prior to the actual increase hitting. Also on that paragraph, at some point, never mind, move off that. Next, I would go to page 15 of that exhibit. This is the paragraph 14 of the lease, entitled Lease Terminations. This is 14B, which is terminations by management. And I've underlined the appropriate sections here. Material noncompliance is one or more substantial violations, including any substantial violation of any addenda to this lease or the rules and regulations attached. Argument here is that failure to recertify or cooperate with certification is the substantial violation. Go to section 2, it actually spells out substantial violation of this lease includes, but is not limited to, A, failure to respond to recertification notices and provide necessary certification information. Again, the argument goes that by submitting it as late as she did, there was no way to effectively pull this off. So they would say, plaintiff's argument would be that under 2A, defendant committed a substantial violation, that is material noncompliance. Next page goes on to subsection 3 of B, and it is other good cause. Jumping down to subparagraph E, failure to provide requested certification information or misrepresentation of certificate information. Certification information is information provided by the tenant which is used to make rent, income, or eligibility determinations, and it is requested of the tenant at least annually and more often if necessary to provide by the lease, as provided in the lease, Number 4, failure or omission of management to terminate this lease for any cause shall not destroy the right of management to do so later for similar or other situations. There's a good argument that last year, when she turned in her stuff by her own admission 5 days before the expiration, they could have terminated then. They chose not to, but this time they are choosing to go forward when what she turned in 2 days early was just the checklist. What she did last year, 5 days early, was the verifications that need to be sent out to people to get back. So she was a step further down the line last year and did it 5 days early. Here she did the first step 2 days before the lapse. So that's the difference in that. And Your Honor, I think that's all I have for lease language paragraphs that are relevant to this part of it. And so I believe that's all I have for opening.
All right, Ms. Bauer.
Thank you, Your Honor. Subsidized housing properties have the responsibility and the obligation to know what their rules and requirements are and what their reporting burdens are. It is not the burden of the tenant to navigate their lack of knowledge or their inability to comply with the intricacies of the rules. Mr. Fleeman indicated in his opening argument that I may be confusing HUD handbooks and Department of Housing
Rural
and
development.
Urban Development handbooks. But handbook HB 2-3560 is a rural development handbook. It is not a housing and urban development handbook. In fact, it indicates, I apologize, Your Honor, I pulled up Mr. Fleeman's documents while he was talking, even though I'd set this one aside. But the very first page of the handbook indicates that it's relevant to Section 515, Rural Housing Services Properties. Chapter 8, which I sent over to the court as Defendant's Exhibit E, is relevant to rental subsidies. And the page 8-1 references 7 CFR 3560.252. That's the Code of Federal Regulations sections for rural housing development, U.S. Department of Agriculture, Rural Housing Services. That's a sub-agency of USDA. And the agency that actually oversees this type of property. And Section 8.2 talks about authorized rental subsidies. And if you turn to page 8-2, specifically authorizes tenant-based rental subsidies. HUD Section 8 vouchers may be accepted by borrowers in agency-funded multifamily housing. And as Mr. Fleeman himself pointed out, the use of the word agency in this case refers to Rural Housing Services. That's the subsidiary of the Department of Agriculture. The last sentence of that first paragraph says projects accepting tenants who use such vouchers assigned by a local public housing agency, Housing Choices LLC, again, as indicated by Mr. Fleeman, will also comply with any requirements imposed by that agency. And the section goes on to indicate that more than one type of subsidy may be used in a project. So, okay, well, just because another subsidy can apply, and just because the property has to comply with the regulations of the housing and urban development subsidy in this case, doesn't mean that they don't also have their own more strict rules that must be followed, and that if they haven't followed those strict rules, then they can't proceed, then they have to evict the tenant. Well, there's a response to that. The Department of Housing or the Department of Agriculture was prepared for that situation, and specifically indicates that essentially that if another subsidy is involved, then the rules of that subsidy and the certification of that subsidy program will control. And to support that argument, I direct you to Section 2 of the handbook excerpt that I sent over, which starts on page 8-15. But the relevant excerpts of it begin at the very bottom of page 8-19, Section 3, Other Rental Subsidies. And it specifically looks at paragraph 8.12, discusses HUD rental subsidies. So this again clearly isn't a housing and urban development handbook, or there wouldn't be a reference to HUD. It would be referring to itself as the agency. But anyways, the agency encourages the use of HUD Section 8 vouchers. Okay, well, of course they do, because they want subsidies to help further their project. But turning to page 8-20, the Public Housing Authority issuing the vouchers will be responsible for an annual examination of household income and family composition. Not the property, not the borrower. The Public Housing Authority issuing the vouchers will be responsible for an annual examination of household income and family composition. The Public Housing Authority will adjust the housing assistance payments made, etc. The very last paragraph I guess subparagraph of paragraph 8.12 indicates that once a HUD assistance contract expires, then recertification responsibility reverts to the borrower, and the agency form and income verification and certification requirements apply. Basic statutory interpretation and construction indicates clearly the rules of the Housing Choice Voucher Program and the HUD program control the annual examination of household income and family composition in this case. Ms. Vilwalk has evidence that she did not ever lose her certification with Section 8. And just to look at the statutory authority that Mr. Fleeman himself presented to the court, in Ms. Vilwalk's answer, she actually referenced that very statute. And there's a basic difference between and or. If you look at paragraph A of 7 CFR section 3560.152, paragraph A says, except for this exception in paragraph B, the tenant is eligible for occupancy if they are either a United States citizen and they are very low or low income, or they're eligible under the requirements of another program, such as HUD, essentially. So both the Code of Federal Regulations and the handbook that informs the practices that plaintiff must follow indicate that eligibility, qualifying, continuing to be eligible under a housing choice voucher is sufficient to be continually eligible to reside at the Section 515 rural development property plaintiff holds. And that the responsibility for overseeing Ms. Vilwalk's certification falls with the Housing Choice Voucher Administration. Now, Ms. Vilwalk's testimony will present that she requested her entire tenant file and that she was only given 7 or 8 pages of her tenant file. In there will be her previous verifications that they're claiming that she didn't submit on time. And those verifications are generally sufficient for an extended period of time, longer than the duration of time that the certifications, longer than the certification itself. And the reason for that is to give properties a leg up on getting that information ahead of time. But regardless, Ms. Vilwalk complied with the terms of her lease because it says that she must respond by the deadline. Ms. Vilwalk did respond by the deadline. It doesn't say, her lease doesn't actually say that she must have her certification in. So even, I guess what I'm saying is, Your Honor, even if you find that my argument is wrong and that terms of the housing choice voucher don't apply, then you can still find that Ms. Vilwalk complied with the terms of her lease because she did submit her documentation before the expiration of her previous certification. Now, she'll present testimony that she attempted to drop the documentation off earlier, but that the plaintiff's office was closed during the week for whatever number of reasons that may be. And had they been open, then perhaps they would have been able to, then the burden and the responsibility falls on the plaintiff, not the tenant. The tenant, at the end of the day, did comply. Subsequent notices don't, the initial notice requests a meeting. Subsequent notices don't request a meeting. They only put one deadline in there, and that deadline is October 1st. So either October 1st was an accurate time for Ms. Vilwalk to return her paperwork, or it was not, in which case the notices were not really particularly clear. They were not effective, therefore. But
Well, why do they
nevertheless,
call it a deadline if it isn't the deadline? And
Well-
I didn't ask that of Mr. Fleeman, but they gave her, Heather, would you turn your camera on?
Your Honor, I believe there was an issue with the kids getting picked up from the bus, so Ms.
Well,
Vilwalk
this
did.
is a court proceeding, and I can't tell if she's watching or not watching. It's very important. I want to know that she's engaged in the proceeding. All right, her microphone's off, but I want her to be where I can see her. All right, go ahead.
Was that to me, Your Honor? Or to
Yes,
Ms. Vilwalk? Okay.
up to you.
So at the end of the day, the evidence will show that Ms. Vilwalk did return her paperwork prior to the deadline, prior to the date that she was given to return her paperwork. And that the plaintiff decided not to proceed. Evidence will show that in the past, the plaintiff processed her documentation subsequent to the recertification deadline. And so it is reasonable to expect, it would be unreasonable for Ms. Vilwalk to expect the plaintiff to behave differently in subsequent years, unless the plaintiff was trying to pull a gotcha. And so, because not only did Ms. Vilwalk actually comply with the requirements of returning her paperwork, not only did Ms. Vilwalk drop off her documents prior to the deadline she was given, not only has the property done this in the past, and so history of conduct should inform the behavior of the relationship between the parties, or the expected behavior between the parties, but also the terms of this program point directly, the terms of plaintiff's program point directly to the terms of the housing choice voucher, and at no point in time has Ms. Vilwalk failed to be in compliance with her housing choice voucher, and she has evidence to support that, and the plaintiff hasn't alleged that she hasn't complied with that. It's not Ms. Vilwalk's job or responsibility or burden to bear on whether or not the plaintiff knows how to report to the housing or to the Department of, or to the Rural Housing Services that it complied with rural housing service requirements or USDA requirements. It's not Ms. Vilwalk's burden to bear that they don't know how to tell USDA that they've complied with the obligations because Ms. Vilwalk complied with her housing choice voucher. It's Ms. Vilwalk's job to comply with her housing choice voucher, and she did that. And even though she did that already for the year, she did still also return her certification documentations to the plaintiff before the deadline. That is what the evidence will show, Your Honor, and that's why Ms. Vilwalk has asked and will continue to ask you to enter an order of possession for the defendant. Thank you.
And Your Honor, while it's fresh, I'd like to make a response to that.
We don't normally do a response to an opening statement. This is absolutely excruciating. We're going to be here until midnight tomorrow to complete this. We haven't even gotten any testimony or evidence yet. But I'll allow you to respond. Maybe it'll help me understand the issue.
Well, I think, not to sound facetious or degrading, but I think Ms. Bauer said several things that were just flat wrong. And no point, and I've said this at the first hearing, there is nothing in any subsidy, MISTA, HUD, or any other, wherein you turn in all your documents and you are done. It doesn't say that. I'll direct the court specifically to exhibit number 2, the 90-day notice. It does not say turn in your documents. The first paragraph says, enclosed, please find the information checklist, which should be filled out completely and by each member of your household who is 18 years. Upon completion of these checklists, please contact me so we can set up an appointment to review the information which will be provided and have you fill out the appropriate verification forms, which we will send directly to the verification sources.
So your position has been, all you got was the checklist 2 days under the door, but the rest of the process was not completed.
And there's no way you could complete it. So that's it. Also, going back to specifically the Exhibit E, which is the Chapter 8 rental subsidies from the HUD handbook, rural development handbook that Ms. Bauer is talking about. And at the risk of being more excruciating, let me take a quick side and say, in federal regs or federal subsidies, you have the regulation section, in this case, 7 CFR 3560. Attached to the end of that, you have a handbook. Now, the statutes were written by the legislators. The handbooks apparently were written by the regulators. They don't always mimic one another. And this is one of the cases, I haven't found many of these, but I have found some. I have found a couple, and this is one of them where the handbook language does not mimic the statutory language. And that comes in a minute here. But before we get to that, on 8-2, when they speak of projects accepting tenants who use vouchers assigned by local public housing agency will also comply with any requirements imposed by that agency. As Ms. Bauer states, basic rules of legislative construction, no construction that renders a word superfluous can be appropriate. To ignore the also is what is happening here. To say that somehow all she has to do is the MISTA process ignores the word also in that. When you get to this section on 8-20 that speaks of once a HUD assistance contract expires, recertification responsibility reverts to the borrower, and agency form and income verification and certification requirements apply, that Ms. Bauer is using as clear implication that somehow the HUD or MISTA voucher trumps the rural development thing. That line is not in the statute. If you go to 7 CFR 3560.260, which is the section that this is talking about, that whole line simply isn't there. And I don't know why it's not there, but it's not there. That's on the statutory line. And what I was saying about confusing HUD and rural development handbooks is when you go to the HUD handbook, it says specifically, if you have a MISTA voucher, you don't need to do your HUD certification. The rural development handbook has no such paragraph. There is nothing. It says, yes, you can do these also. You can do these in addition to. It doesn't say anything about in lieu of. And that's the argument that's being made here, is that because she was in compliance with her MISTA voucher, the lack of compliance for rural development is irrelevant. And I would say that it's not exactly correct to say also that there's no burden of the tenant here. This is meant to be a back and forth process, as the instructions and as I've explained over and over again. This is a process or a procedure, not a one-time deal. But anyways, at this point, I'm ready to have some testimony by Amanda Palmerton.
All right. I don't know that you need any. You've got all your exhibits in place and you've argued how they apply.
I have about 3 questions, basically.
All right, Ms. Palmerton, you are under oath. Would you state your name for the record, please?
Amanda Palmerton,
Spell your last name.
Palmerton.
Mr. Fleeman?
Ms. Palmerton, what's your position with Medallion Management?
I'm the resident specialist at the corporate office.
And how long have you been doing this job?
I've been at the corporate office for 7 years, and I was on site for 7 years prior.
Okay. Have you ever been informed by rural development or MISTA representatives on either side of this that in a rural development property, if a tenant has a MISTA voucher, you no longer need to do the rural development certification?
No, we've never received notification of that.
Have you ever not done rural development certifications in addition to tenant voucher when you know a tenant has a voucher?
No, we've always completed them.
Does the group Housing Choices LLC, do they share with your property, or Erie Street rather, any of their certification information for you to use in your certification?
No.
Okay. And how long are verifications good for in rural development property?
They have to be within 90 days of the effective date of the certification.
And how long are verifications good in a HUD property?
Within 120 days of the effective date of the certification.
So they are valid a little bit longer, but not for the whole length of the annual certification, correct?
Correct.
Okay. Your Honor, I think that's all I have, unless as we get into this, as you said, this is pretty confusing. So there may be other issues that we need Ms. Palmerton to enlighten on. But I
I
think,
will, Ms. Bauer, allow you to cross-examine. I have a criminal matter and the chief public defender is here. He would really like to sit in on this, I'm sure, but I have to take care of this gentleman who's in custody. So I'll let you finish cross-examination and then we'll take a break while I address that. Let me say this, Ms. Villalobos and Ms. Bauer. Mr. Flynn, I haven't heard your side of the case, but the regulations seem to support the plaintiff's intended action. And she runs the risk of being evicted on the 6th of February, which is a Monday. All right, go ahead and cross-examine and then we'll take a break.
Thank you, Your Honor. It's Ms. Palmer, right?
Palmerton.
Palmerton, my apologies.
That's okay.
Ms. Palmerton. Mr. Fleeman asked if you've ever been informed by rural development that you don't need to get certifications from people with HUD vouchers, right?
Correct.
Have you ever asked?
No, we did reach out yesterday to see if they'd heard of any of this, but he said he was looking into it because during his time, he's not heard that question come up.
That's my only question, Your Honor.
All right. You guys are free to stay here and watch what I'm about to do. I can put you in a breakout room so you can talk to your client or whatever you prefer. It's going to take me about 10 minutes to get this guy in here and deal with it. Do you wish to talk to your client or you wish to just sit in on this criminal matter?
I would certainly take the opportunity to speak with my client, Your Honor.
All right, thank you.
Thank you.
Hello, Deputy Kennedy. Could I see Joseph Christ in my courtroom? This is Judge Middleton calling. All right, thank you. Bye. Sorry about that, Keith. This is taking longer than, well, I thought it was going to take a long time, but it's moving quite slowly.
Oh, you're fine, Judge.
All right, and I brought you folks in. You're in an open courtroom. I guess you can watch a bench warrant bond violation arraignment.
Your Honor, if I may, the only case, and I reviewed your email, the only case number I was provided with was 22-2147. But I suspect from what was brought to my attention is there's actually multiple cases of bond. Is that correct?
Well, there is. He also had a no assaultive or threatening behavior in the earlier case.
Got it.
And it would also, I think, violate the terms of the personal protection order. But I tried to cite every case. Now, there's 3 additional cases that he owes money or jail that I mentioned yesterday. Maybe we could address at a later time if he ends up remaining in jail.
Do we know if a PPO hearing has been set or a violation?
No, it has not.
Okay.
Not to my knowledge. Mr. Chris, can you hear me?
Barely, but yes, I can hear you.
All right. We're gonna return to the matter you were asking us about yesterday. It would have been very helpful if I'd known what I know now when we were there yesterday. Nobody seemed to know the right hand, what the left hand was doing. This is in the matter of Joseph Patrick Christ. File number is 222147. In that case, Mr. Christ, you're charged with 2 counts of domestic violence in that matter. We had a last pretrial before jury trial yesterday, and your attorney, Melissa Halleck, was present. You were also on bond in an earlier assault and battery case, file 221627. That matter is set for jury trial in April, and your attorney in that matter is Timothy George. You're also subject to a personal protection order that prohibits certain things. And file number 21926. The matter of Tanya L. Christ versus Joseph Christ. You were here yesterday, and we learned just before the hearing that you had been arrested by the Three Rivers Police Department for alleged violation of your bond. We didn't know which bond it was, whether it was the PPO, whether it was which case. Today, I received a notice of a complaint regarding bond violation. Your lawyer, Melissa Halleck, is not present, but the Chief Public Defender, Keith Stickley, is here. I tried to send an email. I did send an email today to everybody I thought would be involved in this to understand what the current circumstance is. So the prosecutor that was here yesterday, Casey Strong, is unavailable. Deborah Davis from the prosecutor's office was going to be here, but apparently she's occupied. At any rate, Mr. Christ, here's the allegation. Joseph has engaged in drug activity, according to the family. On today's date, Joseph spit in the face of Anita Christ and 15-year-old Elena Warmack. And the cops got there at about noon yesterday and took you into custody for being a pain in the neck. In addition, I mentioned there were several cases that you owed the court money and haven't paid.
But there's no new charges?
I don't
Just
know.
bond
This is an
violation?
allegation that you violated your bond. You owe
Okay, 'cause I-
$375 or 3 days and filed 211409 FY, use of methamphetamine. You owe $350 or 3 days and failed to pay on a disturbing the peace reduced from assault and battery, and filed 202884 SM. We no longer do $350 or 3 days, but that's the way it was written. Anyway, you've got unpaid fines in those 2 matters. You also have an unpaid fine in another case. The assault and battery was an assault crime reduced to disturbing the peace. The methamphetamine charge was a drug offense reduced from a felony to a misdemeanor. You also have some unpaid civil infractions. In addition, in 2022, you were charged with another domestic violence second offense and filed 22771. That matter was dismissed in April because the complaining witness, as I understand it, was uncooperative. So you've been charged with 3 assaultive crimes in the same year, and there's a personal protection order against you. You also failed to pay fines and costs in previous offenses. So the allegation is that you violated your bond by engaging in drug activity and spitting on 2 family members.
I was spit on.
Hang on, stop. Don't talk. I'm helping you out.
Yeah, you'll have a chance to present your side of the facts. Anyway, you're entitled to have a hearing regarding the fact that you violated your bond. It actually could be expanded to include the bond in both cases. Your lawyer, Ms. Halleck, was here yesterday. I proposed trying to resolve all of your cases at once. You weren't in favor of that idea. So I'm assuming you wish to deny the bond violation allegations. Is that correct?
If I just plead guilty, is there any chance of me going home today?
No,
There's no chance of me going home at all?
no.
Why? Like, I don't understand. I don't, how much, what is the charge for a bond violation? What does it carry up to?
Well,
Up to the maximum offense charged. Mr. Chris,
I don't understand.
all right, my fear is that you are out of control. I think there's an underlying methamphetamine issue. You've been charged with assaultive crimes 3 times in the same year. You were on bond on the first assaultive offense when you got arrested for the second assaultive offense. I put a condition on there that you not engage in any assaultive or threatening behavior. There's also a personal protection order that says you're not to do that. So you allegation is A, you're using drugs, which I assume is methamphetamine. B, but that's not very clear. They're going to need to be more specific about this. B, they allege you're spitting on people.
But
I'm not sure what this was about. Now, at one point, your mother had a personal protection order to keep you from living at her house. She met with Judge Pattison, and that personal protection order is in 21926. In December, and as I understand it, your mother was concerned that you were going to get out of jail and have nowhere to live. So they lifted the condition that you could be at the house, but left the other conditions in place.
I just would like, sorry.
Go ahead.
Ever since it was amended to where that I can be there, but I'm not to do anything, it seems to be that I understand if my family doesn't like me anymore, but instead of telling me they don't like me and telling me to not talk to them and just have me be there and not speak to them, which I was trying to do, they decide that I'm now their whipping boy and people are yelling at me, people are stealing from me, and that I just have to accept it because if they call the cops and say I did something, their police department, oh, yep, he did it because I was spit on, I was attacked.
all right, hang on. Let's
All right.
cap it at that. Your Honor, if I could ask, obviously the court signaled that they're not interested or bond would not be possible at this moment. If if any of those files have pay or stays, amounts with the jail hooked, would he at least get jail credit?
Yes, that was my intention. I'll take a look at these on Monday and probably wipe out the stay components of those. They don't exactly have pay or stay anymore, but
I know, but
I could do him a big favor and wipe out quite a bit of money that he owes.
that would be helpful, I'm sure, Your Honor. And I think it would be appropriate just to reset, have everything set as you mentioned, and we can move forward.
I'm gonna set this for a bond violation hearing.
When? I'd rather just, I'd rather.
Hang on.
All right, it'll be
Hang on.
next Friday morning at 9 o'clock.
I'd rather just plead guilty.
Hang on.
Well, that's a possibility too, but I want you to have an opportunity to talk to Miss George or Mr. George and Miss Halleck. Joseph, maybe we can take care of everything you've got pending. All your unpaid tickets, both of your assault cases, but I'm gonna have both of your lawyers there at the same time. Set for a bond violation hearing February 3rd at 9 o'clock. Notice to prosecutor Melissa Halleck.
But I just don't understand.
That morning is
No.
absolutely packed, and I wanted to go to Mrs. Talbert's funeral, but I don't think I'm gonna make it. Your bond is denied,
What do you mean?
means there's
I
no
didn't know I had
bond
bonds.
until I see you next Friday at 9 o'clock with your
But you're
lawyers
not revoking
here.
my other bonds?
Well, I'm revoking it in this one.
And
You're
what-
not charged
I
with
don't
violating
understand.
the other one. Probably that's what will happen.
You're gonna
Perhaps
revoke
there's
my
a,
bond?
well, I'm only revoking it for now. You're entitled to have a bond after 28 days in a PR, in a misdemeanor case. I can't leave you in custody indefinitely. but I'm concerned that someone's gonna get hurt or
I-
you.
It just doesn't make sense to me with no, like, the police obviously realized that I didn't do anything because they didn't try to charge me with anything new because I
That's
didn't.
up to that's up to the prosecutor, not the police. But
So,
now,
I
this
just
is
don't-
hearsay, but that was related to me. They were sick up and fed with you. And they picked your ass up and took you to jail because they didn't want to deal with it anymore. The charging process is up to the prosecutor. So
But there
we'll
is-
deal with this on Friday when both of your lawyers are here. And maybe you have a little clean time in the meantime. All right.
Judge, I think we're this close.
All right, we've lost the defendant.
Uh-oh, she and Meg were speaking on the phone when we were in the breakout room.
Will you need to go back in the breakout room?
No, I don't believe so. I think we have we have a very favorable offer on the table, and I think she's going to try to sell it. And I hope the answer to your question is no.
Okay.
Hey, Tyrone, will she get the same message we did? That it's time to come out of the breakout room?
Yep.
Okay, all right.
Hey, we're good to go. Or, I'm sorry, Attorney Fleeman.
Okay, we're good to go with that. All right.
We lost Heather some while ago, and you had phone contact. Can she log back in?
She's gonna try right now. I guess she was like, I have no idea what happened. She ended up trying to restarting her phone. I told her that if she tried and couldn't get in, then we'd call her. Either the court would call her. Sorry if I overstepped on saying that.
That's fine, that's fine. Meg, why don't you email me her phone number?
Okay.
Hey, Your Honor,
Yes, sir.
is Amanda and Shasta from Erie Street, are they still out in a break room or a breakout
No, I
room?
brought them back in the courtroom, so they're here with us.
Okay, thank you, sir.
Sure. Here she is.
And yes, a little too late. I got you the phone number there.
Well, here she goes.
Oh, there she is.
Good afternoon, Heather. Welcome back. Can you hear me? Could you unmute your microphone?
Yeah, sorry.
All right, thank you. Let me turn the record back on. We are returning to the record in the matter of Three Rivers LP Medallion Management versus Heather, not Clarissa. She was the cross-country runner. Heather gave me a sly smile, but I think I confused her with her sister. Anyway, we're all back, and the parties have been talking at some length in a breakout room. We'd heard much eloquent argument about the federal law and the application to this lease and to this set of facts. Mr. Fleeman, I'll defer to you. What's our current status?
Your Honor, I believe we have reached an agreement and that we will codify in the form of a conditional dismissal. And it will say that the defendant shall vacate the premises on or before February 28, 2023. The second paragraph will be that the plaintiff's pleadings will be amended to request a money judgment request And that's relevant because number 3 is going to say that the defendant will pay $1,250 through February at the rate of $125 a month, starting on March 15, 2023, until that's paid in full. If she does not vacate by the 28th, plaintiff can file an affidavit of default, a judgment, and an order of eviction. If she does not pay the payments as set forth, plaintiff could supply an affidavit of default and a money judgment for the balance remaining for that $1,250, less any payments made in between the order and the default. And that plaintiff shall provide a neutral reference to MISTA and prospective landlords. And Your Honor, it's important because MISTA sends, when they move a voucher, they send something asking if the tenant is in good standing. So, and then I attribute Ms. Bauer for being smart enough to catch that. I had forgotten that point. And that the reason we're doing this payment arrangement in a written form is because that will show to MISTA that she's got an arrangement and she's making payments and therefore will be in good standing. This will then allow her to move that voucher to another location. Ms. Bauer, did I miss anything?
I do not think so, although I noticed my client unmuted. Ms. Vilwalk, is that your understanding?
Yeah, sorry, no, I muted it for a second because my kids, sorry.
So Heather, by the terms of this agreement, you agree to vacate by February 28th. That's 2/28, not 12/28. 2/28 of 23, the end of this month. You will agree to a money judgment of $1,250 payable $125 per month starting February 3rd. If you do not vacate or pay, the plaintiff may request a immediate writ of eviction and a money judgment.
Judge, can I?
Yes.
I just want to clarify, you said that she would agree to a money judgment of, but it's.
She agrees to pay this. If she doesn't pay it, they can request a money judgment. So that this isn't a money judgment, it's a
Conditional dismissal.
It's conditional dismissal. All right, thank you for clarifying that.
Thank
So
you.
it won't go on your credit as a money judgment. That's important too. And they will provide a neutral reference which allow you to find other housing and more importantly to keep your MISTA housing voucher. Did you hear everything that Mr. Fleeman said, Ms. Vilwalk?
Yes,
And you agree with those terms and conditions?
yes.
All right, anything else we should place on the record, Ms. Bauer?
I'd like to ask my client if she enters this agreement freely and willingly. Do
Yeah.
you, Ms. Vilwalk?
Yeah.
Did anybody force you to enter this agreement?
No.
And it looks like Mr. Fleeman wants to add something.
I did, and it was going to be that, that any other money issues other than what we've talked about here will be handled in the ordinary course of business and pursuant to the Michigan Security Deposit Act. And I want to add that clause only because if in the process of moving out, there's some damage to the property, which statistically is the most likely time to do damage to a property is when you're moving out, then there would still be a recourse for that. And I believe, well, I don't know if I believe there may be a security deposit at issue here that needs to be processed through the normal, security deposit process, but that's outside of what we're talking about here. I just wanted to clarify that, and I'll add a paragraph to that effect.
Heather, let me tell you a couple of things. When you do move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. And that will trigger the security deposit law. A long time ago, I read you a set of rights about a tenant in a landlord-tenant proceeding, and now some of those have become relevant. So let me repeat them. If you reach an agreement with the plaintiff and a consent judgment is entered with the court, which is what we just did, you'd waive your rights to have a trial, which we were in the middle of, and all of those rights. But you have the following additional rights. The judgment may not be enforced until 3 business days have passed. You could move to set aside the judgment within those 3 days if you misunderstood what you consented to, what you were waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment would stand. Essentially, it states you have 3 days, 3 business days, which would be Monday, Tuesday, Wednesday, if there's anything different. Mr. Fleeman who's going to prepare the order? You are?
I was going to prepare it, and I will submit it under the 7-day rule and get that handled. Do the 4201I rights apply when a party is represented?
I don't know, but I figure it doesn't hurt to do it.
Doesn't hurt. I just suddenly question crossed my mind.
It may be, you may be right. It may be for unrepresented defendants, but
Doesn't matter.
all right, doesn't matter, I guess. All right. The 7-day rule means he's going to send a copy of it to your lawyer. If it reflects everything that has been said here, nobody needs to do anything. It will simply enter. If there's a dispute or there's a disagreement over what's in it, we can have a further hearing regarding that. All right, you guys all put a lot of hard work into this. And as I said, it was excruciating, but I think it was just excruciating for all of you as it was for me. Anyway, late in the day, we have reached an agreement. Vilwalk, you're gonna have to move. You've been there for some time. And I think this was coming inevitably at any rate at some point. Anyway, I appreciate everybody's time and effort into this matter. I'm gonna